Welcome
Your
to
go-to
today's
resource
live.
for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys come together to engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is GB Satusa, and I'll be your host for today's timely discussion. H-1B Reform 2025. What's real, what's rumor, and what's next? With H-1B reforms on the horizon, 2025 is shaping up to be one of the most pivotal years for employment-based immigration in recent memory. From proposed fee hikes and stricter wage rules, talk of new caps and lottery changes, professionals and employers alike are asking the question, what's actually happening, and what should we be preparing for? To help us break it all down, we're joined by attorney David Katona, a seasoned immigration attorney with deep expertise in both business and family immigration matters. His practice covers a wide range of visa categories, as well as green card sponsorship, family petitions, citizenship, removal defense, and appeals. Known for analytical approach and client-centered advocacy, Attorney Katona helps employers and individuals navigate the evolving U.S. immigration system with strategy, clarity, and precision. Welcome, Attorney Katona. We're glad to have you on the show.
Glad to be here. Thank you for having me.
Now, before we begin, a quick reminder. ImmigrationQuestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals, professionals, and employers can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and share this link with your colleagues. If you haven't subscribed yet, now's the perfect time. Just click on the subscribe button to stay informed on the latest US immigration updates. Now, let's dive into today's discussion. Attorney Katona, could you start by giving us a clear breakdown of which proposed H-1B changes in 2025 are real versus rumored? What do we know for certain so far? And what's still under discussion?
Okay, well, happy to dive into that. So there's quite a lot happening, as everyone is aware. One of the very sort of hot topics at the moment is the weighted lottery rule. It is a notice to proposed rulemaking, which means that it is not finalized as of yet. However, the government did publish the proposed rule, did allow for a very short window of public comment, shorter than usual, 30 days. I was involved in actually commenting on that. And, they will now digest that public comment and propose, finalize the rule and issue a final rule. Now, we don't quite know when that is going to happen. Presumably, there would have been quite a bit of public input. And so the speculation is that it would happen sometimes towards the end of the year or early next year. Whether it will be in time to impact this coming year's lottery is an open question. One of the requests from the Bar Association was that if the rule does take effect, that it take effect for the next year's lottery, not this year, to allow employers time to prepare and better plan. Now, what the proposed rule, is proposing is that, higher wage offers would be given a greater weight in the selection process. For example, if an employer offered a level 4 wage, then that H-1B registration would be given 4 submissions in the lottery, and therefore have an increased likelihood of being selected. And a level 3 would be given 3 submissions, and so forth. So that one is sort of on the horizon. It's real, but we don't know the final specifics of that yet. There is also, of course, the presidential proclamation that was announced in September about the $100,000 H-1B fee. There was a lot of open questions and speculation on that one. Some of those were answered a couple of weeks ago. The USCIS issued a updated FAQ that basically clarifies that is really designed for people who are outside of the country filing a new petition. It's not going to impact people who are filing for extensions, changes of employer, changes of status inside the United States. So that was quite a big relief. There's still some open questions that need to be answered. If someone held an H-1B previously, for example, returned back home, and they'd now like to apply not under the lottery, but like exercising the remainder option, which is where you can come back and reuse the remaining 6-year period under which you were, when you were in your initial H-1B selected. There's a question about scenarios like that, whether the $100,000 fee would apply in those types of scenarios. So that is real, but it is also the subject of a couple of lawsuits, potentially more. U.S. Chamber of Commerce filed one, and so probably in the coming weeks we will have some news and developments about whether or not that type of fee is going to be enjoined and whether it's lawful. There is also updates from the Department of Labor. They announced Project Firewall, which is basically an initiative whereby the Secretary of Labor can actually initiate investigations of H-1B compliance. Normally, historically, these types of investigations were initiated through the Wage and Hour Division, through complaints filed by employees that weren't getting paid properly or at all in some cases. But now they're going to they're going to be able to initiate these on their own. And so we are obviously sensing that there's going to be enhanced compliance reviews and potential inspection for compliance and audits for compliance. So employers that do participate in the program are advised to look at their compliance procedures and make sure that things are in line and work closely with their attorneys on that. While it doesn't necessarily relate exactly to H-1B, but there's also a notice of proposed rulemaking that is going to potentially impact students who are heavy users of the H-1B. And that notice of proposed rulemaking is proposing that fixed authorization periods be granted to students, because right now students are granted duration of status, which allows them to essentially maintain their status as long as they're in school without having to file for extensions. And there's a proposed rule that would limit the period of admission to 4 years, which means that the students would have to apply for extensions if they want to continue beyond 4 years. And there was quite a bit of commentary put in on that one as well. So those are what are actually in play. There's also talk about in the presidential proclamation related to the $100,000 H-1B fee. There was a directive by the administration for the Labor Department to revise their prevailing wage rules or scheme. This was attempted in the initial first Trump administration, and it was actually stopped in the courts. But there is going to be a renewed attempt, allegedly to publish a new rule that would increase prevailing wages, which could make it obviously much costlier to participate in the H-1B program. There's also rumors of, potential rule changes with respect to just qualification requirements for H-1B and what have you. But there's nothing in the mix as of yet formally.
All right. So we've heard a lot about potential fee hikes and stricter wage rules. Could you explain what these proposals mean for both employers and H-1B workers?
Yeah, absolutely. So yeah, the new wage requirements. I mean, again, there has not been a formal rule proposed about wage amendments. As of yet, there has been the weighted lottery, so I can talk first with respect to the weighted lottery. If that rule does go into place, then obviously, there's a lot of implications for H-1B employers. It would obviously, pressure them to increase wages, potentially paying H-1Bs even more than U.S. Workers in some cases, which is kind of contrary to the intent. It could obviously favor um, larger corporations that have more financial means to be able to increase wages. A lot of attorneys, myself included, believe that it will incentivize a lot of bad faith action on behalf of employers. Trying to relocate employees to more rural areas where prevailing wages are lower. I mean, there are some provisions in the proposed rule that try and protect against that, but as we know, there's always going to be bad actors and what have you. Although the great majority of employers do show compliance to the best of their abilities, but this kind of encourages that type of thing. And it could also obviously impact employers willing to participate and in these programs. And with respect to employees, it also is going to change the game with respect to how they view this program. If you have an H-1B worker that has multiple job offers on the table, and they're really inclined to go with a startup that has a lot of promise of growth, but is offering a much lower wage, and on the other side, they have a higher offer, from a more established company, but they are less sort of inclined or less of a desire to join that type of company. They may be kind of pushed towards something that they don't prefer just because they might have a higher chance of being selected in the lottery. Also with these enhanced compliance environments, employees also have to start thinking about how compliant could my employer be, because if I join this employer and there ends up being some sort of audit of their compliance, what kind of blowback would that be on the employee? Would that have on the employee? And that's not fully clear yet. Would this be merely consequences to the employer for noncompliance, or would it be deemed a status violation to the employee as well? These are things that the employee should start thinking about as well. So lot to think.
Definitely. There's also been talk about lottery changes and new H-1B caps. How credible are these discussions, and how might they reshape the application process if implemented?
Yeah. So yeah, I mean we talked about the weighted lottery rules, and I think that what the implication really would be is that the larger, more established employers who are able to offer these higher wages would have a much better chance of being selected. And prospective employees that are being offered lower end wages, closer to level one, for example, which tend to be the entry level type roles, students, recent graduates would have a much smaller chance of being selected in the lottery. And really, I mean, already 50% approximately of the H-1B lottery goes to technology companies, right? That could really shift because a lot of the larger corporations tend to be in the technology sector. And much smaller portion of the cap is typically granted to startups and nonprofits, right? But this would, tip the scale in favor of the technology companies, and so it would also reduce the diversity of who is holding H-1B visas, and it would sort of really favor these companies, which is quite unfortunate. And the long-term impact is huge. I mean, if students who are contemplating coming to the United States versus Canada or somewhere else are really looking at their prospects of being able to continue beyond their studies, get a visa, and they're calculating that it's going to be really tough because of these types of weighted lottery systems. They may opt to study elsewhere, and that's lost revenue for the universities. That's a smaller pool of highly qualified applicants. And so the implication of all this is huge and was not really carefully reviewed in the notice of proposed rulemaking, which is one of the comments that were made, is that there should be a more comprehensive review done before this type of rule is even proposed.
Right. So for employers managing ongoing visa sponsorships, what early adaptation strategies would you recommend to stay compliant and avoid disruption under shifting policy landscape?
Yeah, I mean, I think that really, working, very closely with an attorney, working with attorneys that you have confidence in, that are available to, audit your compliance procedures, make sure that they're clearly explaining what your obligations are, to make sure that even if you've been involved in the program for years, and presuming things are going well, does not mean that you've been, following all the proper compliance procedures. And if there's an audit one day, that could result in some quite heavy fines. Also, what we have been seeing is that USCIS has increasingly been RFing on LCA wage levels. One of the hallmarks of the H-1B program is that you don't need a prevailing wage determination from the Labor Department. You can sort of self-select your wage level and wage survey. But the implication of that is that if you get it wrong, and the Labor Department does an audit and determines that you should have been paying some other wage level or using some other survey, they can issue a back wage order. And that could be costly if you have a large H-1B workforce. And we've been seeing that in the H-1B adjudications. We've been seeing RFEs. I mean, not within our firm, but hearing about it in chat messaging boards and what have you. That there are these LCAs being issued where USCIS is questioning whether the LCA that was filed with the H-1B petition, falls at the right wage level given the stated requirements. If you put in an H-1B for a senior software engineer and you're putting in an LCA with a level 1 wage, then why the senior title, right? That's kind of the idea, and it may end up resulting in a denial. So making sure that you're not just following customary practice, but that you're really kind of working closely with the attorney to kind of analyze, are we doing things right, and really being compliant to avoid any surprises.
And for current or prospective H-1B visa holders, what practical steps should they be taking right now to stay competitive and secure their status as the reforms roll out?
Yeah, I think that they need to really be, as I mentioned before, I think researching their options. Sometimes there's sort of this idea that just have to go towards an H-1B, for example, but you may be eligible for some other type of visa. If you're Australian, you'd be potentially eligible for an E3 visa. If you're Canadian, a TN visa. If you're have a extensive experience, perhaps an O1 visa. So exploring alternative options. There are sort of alternatives to the H-1B as well, even in the student visa context, day one CPT, elevating to master's, until you're able to secure an offer that you think will maximize your chances. And really also, analyzing the employers that are offering you, offers. I mean, is you know having that discussion. Thanks for the offer, but this seems to be at a lower wage level, and if we're serious about working together, we might need to figure out a way to increase this. And looking at potential employer compliance issues. Presumably, if the Labor Department starts auditing, there may be some news stories about this, or postings on chat messaging boards, and kind of researching that to see if there may be some employers that are under particular scrutiny from the government, and maybe considering not accepting an offer, or considering that employer. So I really think that prospective H-1B applicants need to be proactive in again, learning their options, and just analyzing things a little more carefully, and really just staying on top of changes in the law. I mean, even if you get an H-1B, right, you're going to have to extend it. And the extension, the rules may be different at the time of extension, than they were when you actually apply for the visa. So really being on top of the changes, and educating yourself on that type of things is important as well.
Thank you. Now, to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for being part of this important conversation. Whether you're an H-1B professional navigating uncertainty, or an employer seeking clarity, this session is about awareness, preparation, and strategy. If this is your first time joining us, welcome again. ImmigrationQuestion.com is a platform where immigrants, employers, and families can ask immigration related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We're also proud to share that ImmigrationQuestion.com is Triple B accredited, a recognition of our continued commitment to transparency, accountability, and service to immigrant and business communities across the US. Attorney Katrina, as an attorney deeply experienced in both business and family immigration, what are your thoughts on how platforms like ImmigrationQuestion.com are helping immigrants, professionals, and employers connect effectively in today's policy climate?
I think it's very important. I think that ImmigrationQuestion.com acts as a filter. There's a lot of misinformation out there, and a lot of speculation. A lot of people get their information from social media, and we know that a large amount of what people learn there is just not accurate, or even correct at all. And immigration is highly complex. I mean, even immigration lawyers working years in the field, take time to develop their expertise. And so having access to professionals where you can connect in these types of webinars to really cut through all the disinformation, and really get to the truth and heart of the matter is, I think, very important. Yeah, and so having that filter is just invaluable.
Thank you for that insight. Before we head into the Q&A, one final question from me. Given the unpredictability around policy shifts, what compliance tips or documentation best practices would you recommend for employers and visa holders to stay prepped as 2025 unfolds?
Specifically with respect to H-1B, or? Yeah, I mean, yeah, I think that it's really important for employers to, like I said, understand the rules, and have their compliance folders, in very good order. And it's, I think, a good idea to also do periodic audits of your records, just to make sure that what even if you amend your procedures going forward, to make sure that what's already been done is correct, and if it's hasn't been done correctly, then to correct it in good faith. Also, I think it's important to regularly, log things like, and document things like changes in, wage increases, changes in job duties, and really understand what implications those have, because certain cases require an amended H-1B, for example, and so really making sure that the employers have procedures in place for, if a particular team offers a increase wage and job relocation to some other office, and the LCA that the H-1B was filed under accommodate for that has to be filtered up to leadership so that leadership can decide whether an amended H-1B needs to be filed. So having those types of procedures in place and vetting those types of procedures, I think, is really important for employers. For employees, similarly, I mean, hasn't been too much of a focus recently, but with increased things like changes in travel, there are particular rules as to how much time you can travel before an amended LCA needs to be filed. So logging, request to the employer to kind of, look at your H-1B status. Do I need to do something here? I think is important, because if it is not done, and it ends up being an issue, then, the employees have at least, requested that review and may be able to use that. For example, if it does end up in a status violation, they may be able to use that as a way to get some sort of a non-protonc approval, which is when, they explain to the government that, hey, it wasn't my fault. And the government sort of overlooks any sort of failure to maintain status, because the employee, it was beyond the employee's control. So really sort of documenting those types of requests. Again, just, really trying to, stay on top of any changes and, any lawsuits and the outcomes of those lawsuits, I think is important as well, because these things can, literally change from one day to the next, and often do.
Thank you. If you're just joining us, we've been in an insightful discussion with attorney David Katona on the topic H-1B Reform 2025. What's real, what's rumor, and what's next? We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible during this session. Right, our first question. I heard about 100K fee for H-1B. Who must pay it and when does it apply?
Yeah, so we touched upon it earlier. So in terms of who must pay it, that would always be the employer. There's no question about that. And when does it apply? It actually has to be paid prior to the submission of the H-1B. But as I had stated previously, it is only designed to apply to H-1Bs filed post the H-1B publication rule, which was September 21st, I believe. And for individuals who did not have H-1Bs and who are outside of the United States. It does not apply to individuals inside the United States, who previously or currently have H-1B status and are applying to extend or change status or amend their H-1B. So again, it is really designed for new initial petitions. But there are still some open questions, about some unique factual scenarios and whether the fee might apply in those scenarios. But it's always going to be paid by the employer prior to the submission of the H-1B. And there's a web portal that the government recently opened where that payment can be made.
All right. Let's move on to the next question. Companies are telling workers not to travel. What is the risk for me since I already have my H-1B visa?
Well, if by H-1B visa you mean the H-1B visa in your passport, then I can't say this as a blanket statement. However, in many cases, it may be fine. But it really depends on the specifics of the situation. If there are any substantive issues to be concerned about, i.e., you are working at a location that was not disclosed on your LCA, and that comes out in the course of an inspection at CBP when you're coming in at the airport, that type of thing can escalate into a problem. But for situations where, employee is fully compliant with respect to the terms of their H-1B, has the visa in their passport, is, working pursuant to the terms of their petition, then it is likely okay. Now, of course, there are always going to be companies and universities that are being extra cautious and advising students and H-1B visa holders to not travel because other strange things can happen. For example, there's been instances of where CBP, the Border Patrol, confiscate someone's phone, check their social media feed, see that they're posting, certain things that might be deemed contrary to the foreign policy interests of the United States, and that can raise issues as well. There are deportability grounds that apply in those types of situations, or and there have been some noted cases in the media about those types of things happening. So, people should also be cautious about, what they're posting in public on their social media feeds. And if the government were to see something like that, would that potentially escalate into something as well? So, that's kind of a more not H-1B, specific issue, but it's a more just broad sort of enforcement objective of the or concern of the government, and that should be taken into account as well.
Right. Next question. There are lawsuits and groups that are fighting the 100K fee. Do you think the court will stop the rule soon?
I do think that it will probably be enjoined or found unlawful. There actually has not been, to my knowledge, yet a motion for a preliminary injunction, which is, when the plaintiffs basically ask the court to issue an injunction to stop the rule from having effect while the litigation is in process, because you have to have damage, and because the rule was just published, I don't think they have identified any plaintiffs as of yet. That might change. But lawsuits can take time. So if there is no motion for preliminary injunction filed, it can take, months for the litigation to play out. I do ultimately think this type of rule will probably be found unlawful because there are obviously, provisions in the law that, give Congress the power of the purse, not the president. Also, there's, restrictions within the immigration statute that, control, when fees can be implemented and what have you. And also the rule doesn't closely align with the stated objective of the proclamation itself. It's going to apply just randomly to, situations, but at the end of the day, people are still going to be able to secure H-1Bs. There are workarounds. If somebody comes in on a tourist visa, applies a change of status to H-1B, then they wouldn't be subject to that fee. Whereas if they applied from abroad, but it's the same person, right? And so it doesn't make sense that it, actually solves, the purpose that the proclamation was intended for. And so typically when there's that disconnect, you see the courts be quite skeptical.
Right. Let's move on to our next question. Right. I think those are our questions for today. Thank you so much, Attorney Katona, for your time, your clarity, and expertise today. Your insights have provided a much needed distinction between real reform and speculation, and given both employers and visa holders actionable ways to navigate what's ahead. And to all our viewers, thank you for joining this timely conversation. We hope today's discussion has helped you stay informed, empowered, and proactive in planning for your future. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with licensed immigration attorneys. Many users may also qualify for a free confidential consultation. If you'd like to rewatch today's webinar or share it with others, the full replay will soon be available on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again next week for another live session where we continue exploring immigration topics that matter most, from employment visas and policy reform to compliance strategies and global mobility trends. Once again, thank you, Attorney Katrina, and thank you to everyone who tuned in. Until next time, stay informed, stay compliant, and stay connected.
Thank you.